for environmental programs here. And our next panel is called The Frontline, Why There's No Green New Deal Without Environmental Justice and Redress. And we have three excellent speakers here to talk to us about that subject. I'm going to introduce each one of them as we go, and then we'll have time at the end for Q&A. Our first speaker is Julian Brave NoiseCat. Julian is Director of Green New Deal Strategy at Data for Progress. He's a writer and has published his writing in many, many places, from the Paris Review to Esquire to High Country News and many, many more. Among other honors, he was invited to consult for the forthcoming UN Committee on Economic, Social, and Cultural Rights on the topic of land rights. He's authored and edited many policy briefs, memos, reports, polls, scorecards, and other works in contribution to progressive platforms such as the Green New Deal. He is a graduate of Columbia University and the University of Oxford, where he was a Clarendon Scholar, and he led 350.org's policy work in the US and was an urban fellow in the Commissioner's Office of the New York City Department of Housing, Preservation, and Development. He is a member of the Kanem Band Tegeskin and a descendant of the Lil'wat Nation of Mount Currie. Please welcome Julian.
Thank you. I think we're gonna have to.
Can you help him get to his?
How does this work?
So that's not his.
Oh. Sorry, just some brief moment here to get our slides in order. While we do that, actually, wait quite up. Julian Brave NoiseCat when squext, when Kika had a squestro Alexander Radia, when Keka had a squestro Edarchi NoiseCat, Sequach Mok and a Statlim and its Eskin which Dequin, let when Poopsman Eliotic to mich where Abenaki Uluch. Hello, everyone. My name is Julian Brave NoiseCat. My mother's name is Alexandra Radia, and my father's name is Edarchi NoiseCat. Among my people, the Secwepemc and the St'át'imc nations in what is now British Columbia, Canada, usually people, when we first meet each other or greet each other, we sort of relate our family lineages and that sort of thing to figure out if we're related. So if either of you are related to my mom and dad, you should come tell me. So it's good to be here today at the Vermont Law School on the traditional territory of the Abenaki Confederacy. This is the first time that I've gotten to come here, and I've worked with, in the environmental movement, a number of graduates of this school. Bernie Sanders, very awesome climate staffer, for example, was a graduate of this law school. So your guys' work is doing good things in the world. Today I'm going to talk about the Green New Deal, the campaign against the Keystone XL pipeline, and what indigenous nations might contribute to bold, ambitious, and equitable climate action. So back in January, I traveled to the Yankton Reservation in South Dakota, where in the bingo hall of the Fort Randall Casino, leaders of the Oceti-Sakowin Nation, more commonly known as the Sioux, had gathered to reaffirm the international treaty to protect the sacred. The treaty was first signed here in 2013, uniting indigenous nations in the fight against the Keystone XL pipeline and the expansion of the fossil fuel projects emanating out of the tar sands in Alberta, the Bakken in North Dakota, the San Juan Basin in the Four Corners, the Permian in Texas, and in the pipelines that snake their way across the continent, connecting oil fields to refineries, tankers, power plants, and gas pumps around the world. Riding this wildcat boom, the United States surpassed Saudi Arabia to become the single largest oil exporter in the world, pumping more than 10 million barrels per day, according to the International Energy Agency. The combustion of all that fossil fuel is, right now, driving the planet to a new atmospheric chemistry. In May, the concentration of carbon dioxide in the air reached 415 parts per million for the first time in 3 million years. The last time that happened, forests grew in Antarctica. the Greenland ice sheet did not exist, and sea levels were more than 50 feet higher than they are today. Our species, people who we would identify as Homo sapiens, did not yet walk the earth. The United States provides the fossil fuel industry over $500 billion in direct and indirect subsidies every year. That's according to a radical leftist organization called the International Monetary Fund. This includes access to cheap leases on public lands, quick and easy permitting processes, and, as we learned at Standing Rock, the cooperation of law enforcement agencies that can serve as mini private armies. In the 1970s, scholars coined the term petrostate to describe a form of state development built from the revenue of the oil rig. But back when the Saudi Arabias and Venezuelas of the world started drilling, the greenhouse effect was little more than a theory, and it would have been inconceivable to power an industrial economy without fossil fuel. Today, of course, we know the science, and we have cheap solar panels. Our economy transacts at nearly $20 trillion every single year. We could do things a lot differently, but instead we have doubled down. Since Dr. James Hansen testified to Congress in 1988, creating widespread awareness of global warming, humans have spewed more carbon into the atmosphere than in all prior history. Renewable energy is in many places cheaper than fossil fuel, and its price continues to drop. Yet on we go. After 3 years of decline, US emissions went up by 3.4% in 2018. President Trump has described global warming as a, quote, hoax invented by the Chinese, and boasts that, quote, the golden era of American energy is now underway. At present, the United States, in league with fossil fuel corporations, has become a uniquely destructive force in global history, one that we may need a new vocabulary to describe, a necrostate, perhaps. Against destruction, more and more people are rising up. Indigenous communities have been among the boldest of the dissidents, asserting our own authority to stop the construction of pipelines and enact a more just relationship between land and people to protect the sacred. South Dakota, where I was back in January, is the land of the Fort Laramie Treaties of 1851 and 1868. Each treaty guaranteed the Oceti-Sakowin large homelands in the center of the continent. Each was broken even before the ink on the parchment dried. In 1980, the Supreme Court ruled that the United States had violated the treaty when, in 1874, it opened the Oceti-Sakowin's sacred Black Hills to prospectors. The court ordered the government to pay $88 million in restitution. With interest, the settlement is now worth more than $1 billion. The Oceti-Sakowin, however, have refused to accept compensation, insisting that their sacred Black Hills are not for sale. Under the authority of the same treaty and others, tribes have been fighting the Keystone XL pipeline, which would contribute 24.3 million metric tons of CO2 emissions every year, the equivalent of Americans driving more than 60 billion addition miles. The project has been tied up in legal battles for the last decade, though industry experts and anti-pipeline activists anticipate construction could begin in 2020. In anticipation of opposition, the South Dakota legislature passed a new anti-protest law that would target opponents of the Keystone XL pipeline, including ranchers, environmentalists, and tribes, with fines for a new crime called riot boosting. Governor Kristi Noem signed the bill into law less than 3 days after its introduction. The ACLU has challenged the law as an unconstitutional violation of the First Amendment. The Oceti-Sakowin would add that it is also a violation of their treaty rights. In the red states that some journalists have taken to calling Trump country, the founding documents of this nation, the Constitution, and the more than 300 treaties signed with Native nations so that these United States could stretch from sea to shining sea, are dead letter. These are the circumstances that transformed pipelines like Keystone XL and Dakota Access into national news. For a decade, pipeline politics shifted the center of gravity in the environmental movement. In 2016, more than 1 million people checked in at Standing Rock in solidarity with the fight against Dakota Access. A Puerto Rican bartender from the Bronx was among thousands of millennials who organized in support. Her name was Alexandria Ocasio-Cortez. Congresswoman Ocasio-Cortez's Green New Deal, like the indigenous movements against Keystone XL and Dakota Access before it, has reshaped the landscape of American politics. 106 members of Congress have co-sponsored a Green New Deal resolution, and 18 presidential candidates have endorsed the vision, including progressive frontrunners Bernie Sanders and Elizabeth Warren. Data for Progress, the think tank where I work, consistently finds robust public support for the Green New Deal, which in turn has brought a word not often associated with global warming into the conversation, and that's justice. AOC and Green New Deal advocates, to their credit, have done a great deal to include issues of environmental racism and injustice in the early design of the Green New Deal. Last month, for example, California Senator Kamala Harris and Representative Ocasio-Cortez introduced the Climate Equity Act, which would prioritize investments in frontline communities in federal climate action. Earlier this year, New York State passed the Climate Leadership and Community Protection Act, which similarly mandates green investments in low-income communities of color. During CNN's town hall on the climate crisis, 9 candidates directly or indirectly referenced environmental justice, which to my mind is probably a first. But one senses that buzzwords like environmental justice and frontline communities are becoming empty signifiers. Empty not because those who invoke them don't genuinely care, but because these terms have yet to be filled with programmatic substance, with what justice might look like for the Oceti Sakowin, for example, or the South Bronx, for that matter. What would it mean to think about communities on the front line of climate change and pollution not only as communities in harm's way or as passive beneficiaries of investments, but instead as architects and drivers of a Green New Deal? So for a moment, let's revert our gaze from the votes we can whip out of lawmakers on Capitol Hill and the blaring studio lighting of the made-for-TV stage and return to that bingo hall in the Fort Randall Casino on the Yankton Reservation in South Dakota. What would a Green New Deal look like if we started building there? Well, as it turns out, the foundation, if not the inspiration for a Green New Deal, already exists in indigenous communities across the continent. Most, including the best intentioned, just don't bother to look. In the values that have called some of the poorest people in the United States to stand up against the largest corporations in the world, we might find the courage that we need to win this fight against all odds. In our Constitution, which protects the right to protest, in theory at least, we might remember that democracy is at least as important and powerful a tool in the fight against climate change and pollution as decarbonization. In the treaties that the Constitution describes as the supreme law of the land, we might find the basis for a more just and equal relationship between tribes and the federal government, one where pipelines cannot be built through tribal lands without consent. And in the sovereignty of indigenous nations, we might find new partners for not only a multiracial, but also a plurinational democracy. In many places like South Dakota, where the Oceti Sakowin have stopped the Keystone XL pipeline for the last decade, indigenous nations have shown how tribes can protect the environment in this perilous age of greed and warming. And though indigenous nations' inherent and enduring self-determination, we might begin to reimagine and rebuild the state as a home for the many nations of this continent, and especially its First Nations. And with the intergenerational memory and experience of a people who survived a genocide and knows what it means to live through the end of their world, humanity might learn a thing or two about how to endure through the oncoming climate crisis. So what might a Green New Deal built with, rather than for, Indigenous peoples look like? It would look like honoring what came before. The treaties, the tribes, the rivers from which we drink, the air which we breathe, the land where we plant and gather our food and to which we return when our time is up. And by finally honoring these things, which have always been there, but which this country has never properly respected or protected, we might build something green and new. Back in February at the Fort Randall Casino, I was asked to sign the international treaty to protect the sacred as the lone representative of the St'át'imc Nation in attendance. When it was my turn to speak, I decided to share my great-great-great-grandfather, Chief Harry Nkashusha Peters' song, which many forces, germs, governments, missionaries, and markets have conspired to take away from my family, but which we still remember and sing to this day. We may need some new technology to fight climate change, better batteries, some new shipping technology, a better way to do air travel, definitely wouldn't hurt. But in truth, the Green New Deal can be built mostly through the power of things that have always been there, the sun, the wind, the indigenous, but whose potential we have yet to fully unlock. Kukschem, thank you.
Thank you. Next, we will hear from Professor Andrea Freeman. Andrea is an associate professor of law at the William S. Richardson School of Law at the University of Hawaii. She writes and researches at the intersection of critical race theory and food policy, health, and consumer credit. Much of her work explores her pioneering theory of food oppression, which examines how facially neutral food-related law and policy, influenced by corporate interests, disproportionately harms marginalized communities. She also studies the effects of racism by credit card companies against consumers. In summer 2018, she was the Distinguished Scholar of Sustainable Agriculture and Food Systems here at VLS. She's a graduate of UC Berkeley School of Law, and before law school, she worked as a counselor for women and children who experienced domestic violence and as a production manager in the independent film industry. Please welcome Professor Freeman.
I hope we can get everyone who went to the pipeline to come out to Hawaii to protect Mauna Kea. I know it's a little harder to get to than South Dakota, so it's a little bit of a problem. Yep. Okay, so thank you to my moderator, my panelists, all the students who organized this. I came a long way to be here, and I don't regret it. It's wonderful to be here again. And so I'm going to turn the conversation to food justice. I think it's really exciting that the Green New Deal recognizes the link between racism and food policy, or what I call food oppression. So in the preamble, we have this recognition highlighting connections between climate change, racism, and other forms of oppression. We have this section that acknowledges the link between law, policy, and inequality. The resolution to secure healthy food for everyone in the United States and to promote justice. It also then closes with a commitment to building a more sustainable food system, ensuring universal access to healthy food. Okay, yeah. So I, of course, could not agree more with these goals, but the question is how to accomplish them. So some countries seek to ensure universal access to food by including a right to food in their constitutions. Our constitution would need to be amended to create this kind of positive right. And even if there were the will to do this, a constitutional amendment is a complicated process that has rarely been successful. The Green New Deal seems to invoke or reflect the principles and demands of the food sovereignty movement, defined here, but the Green New Deal fails to include a call for culturally appropriate food, despite its acknowledgement of the relationship between racism and food. I'm assuming that that omission stems from a fear of political backlash that is legitimate, because Alexandria Ocasio-Cortez has said, quote, when someone says that it's too hard to do a green space that grows yucca instead of, I don't know, cauliflower, what you're doing is you're taking a colonial approach to environmentalism. If culturally appropriate food is not incorporated into implementation of the deal, it likely will not meet its food justice goals. Ignoring community preferences and leadership has doomed many food justice initiatives. Government food assistance programs also often ignore the needs of their constituents and instead prioritize corporate interests and agency mandates. So in the time I have today, I'm going to focus primarily on two government programs that have the potential to move the United States closer to the food security and equity goals laid out in the Green New Deal. In their current forms, they contribute to instead of reducing food oppression. And these programs are the National School Lunch Program and the Food Distribution Program for Indian Reservations. As acknowledged in the Green New Deal, many of the social programs created during the New Deal in response to the Great Depression exacerbated and entrenched social inequality. So the 1930s saw the enactment of the first Farm Bill, then the Agricultural Adjustment Act, with the twin goals of supporting American agriculture and alleviating hunger. Although relatively successful in the short term, the Farm Bill led to the dispossession of many Black-owned farms and the overproduction of foods that contributed to the next food-related public health crisis, obesity. And this overproduction became the responsibility of the USDA, which relied on its nutrition programs to dispose of some of these surpluses. Subsidized commodity foods dominate the National School Lunch Program and the FDPIR, which serve the populations that the Green New Deal describes as frontlines. So while we think that school lunches look like this, well, they actually look like this. And the USDA promotes the FDPIR as this, when in fact it is this. So the history of food assistance to tribes goes much further back than the New Deal. Colonization involved the deliberate destruction of traditional foodways. As part of the Indian assimilation project, President Washington vowed to, quote, ruin their crops on the ground and prevent them planting more. This policy led to mass starvation. Later, President Jackson justified the 1830 Indian Removal Act that authorized the forced dislocation of tribes to the west by the fact that tribal lands could no longer support the indigenous way of life after the damage done by American occupation. After the 1851 Indian Appropriations Act codified the creation of reservations, the Office of Indian Affairs, housed under the War Department, took charge of distributing food rations. The United States wielded rations as a weapon, withholding them from families who resisted their children's removal to boarding schools or rejected Christianity. The 1862 Dakota War, sparked by the deliberate withholding of rations, ended in President Lincoln ordering the execution of 38 Dakota men, the largest mass execution in United States history. The rations that the government did provide were low quality and unfamiliar. The US deliberately left traditional foods out of these assistance packages to steer tribes toward a, quote, civilized lifestyle. In 1949, the government began sending commodity surpluses to tribes. FDPIR became an official program in 1977 as an alternative to SNAP because of the obstacles to accessing SNAP benefits posed by tribes' isolation on reservations. Today, Indigenous people have more type 2 diabetes than any other racial or ethnic group, and this form of diabetes often leads to paralysis, amputation, and blindness. The rate of deaths is 177% higher. Indigenous adults are diagnosed with obesity 60% more often than white adults. And on the Dakota Reservation, life expectancy for males is between 40 and 50 years old, as opposed to 76 in the general population. So commods, another name for FDPIR boxes, contribute significantly to these disparities. Activist Charles Red Gates recounted testimony he gave to government representatives about the boxes in 1991. Quote, "Did you ever see what's in these cans?" This guy said, "No, show us, we want to see." So I grabbed a can of pork and I told him, "You're gonna get a bad smell. It doesn't smell good and it doesn't look good when I open it, so you take a look." I got a can of chicken, a can of beef, and a can of pork. The first one I opened, everybody crowded around. I opened it up, and as soon as I opened it up, a couple of them backed away and grabbed their noses and their mouths. When I began to dump it out, they both ran outside and threw up. That's what they were giving us. And I showed them all the connective tissue, the blood vessels. It was some pretty terrible stuff. So because the proteins and produce in the boxes are often undesirable or inedible, many recipients only eat the sugars and the carbs. And the contents of the boxes are supposed to reflect the dietary guidelines created by the USDA and the Department of Health and Human Services. Bernard and Brown described the guidelines as, quote, "amounting to perhaps inadvertently the nutritional equivalent of smallpox-infected blankets." The box's gross inadequacy likely reflects the guidelines' allegiances to the food and agriculture industries. Karuk ceremonial leader, Leif Hellman, describes nutritional colonialism through the FDPIR as, quote, "a modern extension of tribal termination and genocide." Now, the USDA defends the poor nutritional quality of these boxes by claiming that they're only supplemental. But 1/3 of program participants rely on them for all their food. Commods and their effects are so pervasive that for some people, they've become wrapped up in a so-called Indian identity, bridging gaps between tribes. For example, only Indians or indigenous people can have a commod bod. Okay. Commodity cheese is beloved across communities. A quiz titled "How to Tell If You're Rezzed Out" includes, every time you see a line, you jump in thinking that you're getting surplus cheese. Musician Wade Fernandez, a member of the Menominee tribe, sings a song called "Commodity Cheese Blues" that includes the lyrics, "I went downtown to the commod shop," sorry, I cannot sing this, "met the blues because they were out of stock. Tell me please when I'll get my commodity cheese." Visa cheese is a term that means a mode of exchange in which a block of commodity cheese can purchase other goods or services. And a 2006 Indian Country Today article observed, quote, "Some Lakota still say to this day that the only brick of gold the Lakota people got out of the Black Hills is the brick of cheese rationed out on Commodity Day." Aside from being highly processed, commodity cheese causes discomfort for many indigenous people who suffer from lactose intolerance and other more serious health conditions related to dairy consumption. Now, the most controversial commod, and perhaps beloved, is fry bread, a delicious creation born of the need to convert flour, sugar, and oil into something palatable. To some, fry bread can be a unifying symbol. And this is the character of Thomas in the movie Smoke Signals, who puts on this Fry Bread Power shirt to show that he is a real Indian. Okay? But fry bread has also become emblematic of bad health and a focal point of outsiders who attribute high rates of diabetes in indigenous communities to their bad decision making. Fry bread has a famous fan, musician Keith Secola, who contends that, quote, fry bread has killed more Indians than the federal government. This is Susan Harjo, who launched a debate with her 2005 New Year's resolution to stop eating fry bread. And she said, quote, if fry bread were a movie, it would be hardcore porn, no redeeming qualities, zero nutrition. So fry bread is not a traditional food, although it is sometimes treated as one. But it is a symbol of resistance to the disregard to indigenous health demonstrated by the very sad contents of the FDPIR boxes. The FDPIR contributes to nutrition transition, a shift from being underweight and experiencing high rates of communicable diseases to being overweight and suffering from nutrition-related diseases. But the structure of the program also sometimes leads to hunger. Elders who receive Social Security are not eligible for the boxes, even though their Social Security income isn't enough to cover food. And the boxes also create stigma, leading some people who are eligible for the program to choose not to participate. Some distribution centers have addressed this problem by switching from boxes to shelves, where participants can browse and select what they want, but it's still a problem in most places. To improve access to healthy food and mitigate some of the harms of colonization, the USDA should use the FDPIR to provide nutritious, culturally appropriate food to people living on or near reservations. And instead of trying to teach program participants how to make do with what they get, the USDA should just improve the program. The food should be sourced from tribes, and community members should run and guide this program. Okay, shifting gears to National School Lunch Program. It began during the Great Depression. In 1942, the program fed 6 million students. But after the United States joined World War II, the surplus food was diverted to feed troops, reducing the number of school meals served. 40% of draft rejections were because of poor nutrition, motivating Congress to create the National School Lunch Program in 1946 as a matter of national security. In 2009, obesity was responsible for a large percentage of recruit rejections. So some statistics about the school lunch program. 70% of free school lunches go to children of color. On school days, half of the students who get free lunches eat only meals at school. 6 to 8 million Black students in the US have diets that consist almost entirely of what the USDA feeds them. The commodities program gives free and discounted commodity foods to participating schools, which are 94% of public schools in the United States. And milk has its own program. So children of color experience lactose intolerance and milk-related diseases and conditions at the highest rates. And milk is also associated with white supremacy. So here are protesters chugging milk. This was against a anti-Trump installation in New York. These are some leading alt-right people who put glasses of milk into their Twitter names. And this is a thread and a poem that went around on the alt-right circuits about lactose tolerance. So in addition to contributing to racial health disparities, the structure of the National School Lunch Program contributes to food insecurity. There is stigma attached to free school meals that makes many students prefer to go without lunch over suffering the ridicule of their peers. And some students whose families don't qualify or don't sign up for the program but can't afford to pay for lunch must endure lunch shaming from cafeteria workers who humiliate them by writing on their bodies, tossing out their full lunch trays, making them perform chores in the cafeteria, or giving them a cold sandwich instead of a hot lunch. Many of these students prefer going hungry to putting up with this kind of abuse. Earlier this year, a Pennsylvania school district sent a letter home with students whose families had $10 in lunch debt, threatening to have the children removed and sent to foster homes. Yeah. And the district refused offers to pay off the student debts, showing that this was much more about shaming the families than actually trying to get the money. So the National School Lunch Program creates separate nutritional tracks for low-income students and students of color, resulting in lifelong health disparities. And the control that the USDA exercises over the diets and health of students of color echoes back to the control that owners had over enslaved children's diets. Health disparities between whites and blacks in the United States have remained consistent since that time. To start closing that gap and achieving food equity, the USDA should separate the National School Lunch Program from the Commodities Program and provide healthy, culturally appropriate lunches to all students. I also want to take a few minutes to mention the effects of the work requirements imposed on SNAP participants by the Personal Responsibility and Work Opportunity Act in 1996. So SNAP began as a food stamp program in the 1930s, intended to alleviate hunger. It worked so well that it was discontinued in 1943, and then it was revived in the 60s. So SNAP provides cash assistance to low-income families to be used for food. And although it's a Band-Aid type of solution, the program does go a long way toward reducing food insecurity in the absence of structural reform. Work requirements were added to SNAP as part of a racially motivated suspicion of welfare fraud fueled by the stereotype of the welfare queen. So ostensibly intended to promote exit from the program by encouraging participants to work, the primary effect of work requirements has been to decrease program participation and increase food insecurity. And the Trump administration has proposed adding more stringent work requirements and other restrictions that will cut approximately 3 million people from the program. Instead, the administration should expand and replace work requirements with quality education and training programs to funnel people into skilled, well-paid labor that is in high demand. Reforming government nutrition programs to address the legacies of colonization, slavery, and land theft is essential to accomplish the Green New Deal's food justice goals.
Okay, thank you, Professor Freeman. Our third and final speaker on this panel is Professor Gabe Passiniak. Gabe is an assistant professor of law at the University of New Mexico School of Law, where he teaches primarily in the Natural Resources and Environmental Law Clinic. In addition to his work in the clinic, Gabe's teaching, scholarship, and policy work focuses on climate change and energy issues. Prior to joining the faculty at UNM School of Law in August 2017, Gabe managed the Climate Change Mitigation Program at the renowned Georgetown Climate Center and co-taught a climate change law and policy practicum course at Georgetown Law. At the Climate Law Center, he led work to support states in advancing greenhouse gas emissions reductions and clean energy policies in the power and transportation sectors. Gabe is a graduate of Georgetown Law, and prior to becoming a lawyer, he was a community journalist in Washington, D.C. Please welcome Professor Pacyniak.
Thank you, and thank you to all of the organizers. It's really great to be here today, and a great opportunity to talk about the importance of including justice in climate change policy. So I'd like to build on what my co-panelists talked about today. I feel like I'm staring down, so I'm just going to move this up just a little bit. And I'd like to do three things today. One, I want to identify what I see as some of the types of justice claims that are in the Green New Deal resolution, and that I hope to persuade you should be taken seriously and addressed in climate change policy. And then I want to take a little bit of time to think about how that might be systematized and specifically look at administrative climate change policymaking, and which is already a significant part of some of the major climate change policies that we have at the state level. And suggest that, to build on a concept that Julian talked about, that we can use an existing framework, not a super old one, only about 50 years old, but something like the National Environmental Policy Act, to take a systemized approach to consider how justice claims can be addressed through this administrative process. Now, that's not to say that legislative action isn't super important, because it is, and there are types of justice claims, many types, that I think cannot be addressed through the administrative process. But legislation is messy, and it requires people to come together, and you can't put guardrails on it, but you can do that in the administrative process, and that's why I want to suggest that there's a way that you can systematize taking into account these important justice concerns through administrative rulemaking. So with that, let me start by talking about the types of justice concerns that I see in the Green New Deal, or at least one way of categorizing them, and to talk about some of the tensions with the need to address climate change urgently and efficiently. Because in order to be concise, I'm going to not go through the history of these types of justice claims, which occur everywhere in law and society, but rather focus on how I would suggest that we think of them in the climate change policy-making framework. I also hope to persuade you that these four types of justice claims are claims that we broadly hold as moral values, and that you will recognize are deeply embedded in our legal system, although not always to the same degree and with the same universality. So the first one I'll talk about is corrective justice. And the general principle here, from a climate change policy making standpoint, is that when a climate change policy itself harms some community or group of people, then the government has a duty to rectify that harm. And I'll give you two examples here. So one from my new home state of New Mexico, very recently passed legislation that will result in the closure of the largest coal-fired power plant in the state. The major utility argued in part that that closure was going to come about anyway because of the state's clean energy mandate, or renewable portfolio standard. So a corrective justice claim might say that at the very least, the workers who are going to be out of a job because of the closure of that power plant, because of the clean energy policies of the state, that the state has a duty to provide job severance, training, perhaps some economic development for a region that has really relied on this coal-fired power plant as a major part of its economic life. Another example of a corrective justice claim might be one related to cap and trade. And this is one of two critiques that I see of the cap and trade program, of a cap and trade type of program. The corrective justice version of that claim would say that to the degree that a cap and trade program allows for increases of cumulative conventional or hazardous pollutants, that there is a duty to mitigate the harms that result from those increases. And there's some evidence that, for example, in California's program, utilities stopped relying on coal-fired power plants out of the state and used natural gas power plants in the state in communities that were already disproportionately burdened by conventional pollutants and were predominantly communities of color and low-income communities. Professor Kazwan, who's going to be speaking later, has written a lot about this. So that's the corrective justice claim. The second claim I'll point you to is an equality of opportunity justice claim. This one is not always written about in some of the body of environmental justice literature, but I think that it's particularly important in the climate change context. And that's because when it comes to addressing climate change, we need to change people's behavior to a great degree, and one of the strategies that we have to do that is to use a variety of economic incentives. And so the equality of opportunity justice claim in this climate policy making context, I'd argue, can be understood as a duty by the government when it creates new benefits or burdens to ensure that those benefits, that everyone has an equitable opportunity to access those benefits, or that those burdens do not discriminate against certain people or communities. So let me again give you 2 examples. So we know that the transportation sector is now the largest source of greenhouse gas emissions, and that in order to reduce those emissions in the dramatic way that we need to in order to address climate change, we need to shift quickly and dramatically to electric vehicles. The best policy tool we have for doing that right now is purchase incentives, subsidies to purchasers of electric vehicles. That's not the only model out there, but it's the best tool we know of. And so equality of opportunity justice asks, is it fair that right now when we predominantly only have new electric vehicles on the market and that there is still a price premium, that an EV subsidy predominantly goes to relatively rich folks and cannot be accessed by poorer folks who can't purchase a $30,000 vehicle even if they have a $7,000 credit? Another example of this type of justice claim is rooftop solar. Same thing, can't be accessed by renters, lower income folks who don't have the capital to shell out to take advantage of that tax credit. Similar in many ways to what Professor Kevin Jones talked about earlier with tax credits on a community scale. So the third type of justice claim that I see in the Green New Deal is a distributive justice claim. And here, in the context, and now we're all familiar with distributive justice in general. Unlike equality of opportunity, distributive justice is concerned with equality of outcomes. And so, at the broad level, we might be concerned that everyone at the very basic level has access to housing, healthcare, jobs, all things that the Green New Deal seeks. But I'll also point out more narrow and targeted ways that we can see in existing policies that I believe are distributive justice types of claims or ways to address distributive justice. For example, in Washington's new zero carbon electricity standard, there is a mandate to provide energy assistance to low income folks. And so we can, I suggest that distributive justice claims be thought of as seeking to reduce inequalities of outcomes, because we're not in a world where we're seeking perfect equality of outcomes or that the political framework allows anything close to that. But at the very least, we're seeking to reduce inequalities of outcomes. And that's what that energy assistance mandate does, is it says that we will likely see increases of electricity costs and rates as we shift to a zero carbon electricity system, and that we should be reducing the burden of those electricity costs on low-income folks. The last justice claim that I'll point out to you all is the procedural justice claim. This is a foundation of the environmental justice movement and stands for the principle that those people who are affected by these policies, that are perhaps harmed, that are otherwise underserved or underrepresented communities of color, low-income communities, or frontline communities like coal worker communities, have a meaningful input into the policymaking process, something that we heard both of my co-panelists refer to today. So there is, of course, some tension here, because as we heard in the earlier panels, addressing justice claims, these types of justice claims, can, in some, but not necessarily all situations, raise the costs of reducing greenhouse gas emissions, and potentially raise the amount of time that it takes. And as the Green New Deal resolution itself calls for a 10-year time frame for achieving carbon neutrality, at least some would say that there's some incompatibility between perfectly just and perfectly efficient or as cost-effective climate policies as we can reach. So what I'd like to do today is argue that we need to take justice seriously, and I hope that by at least going through these types of justice claims, I've persuaded you a little bit that these justice claims are based on broad moral values that we share as a society and that are reflected in our legal system. Next, what I'd like to do is argue that we should try to systematize a way to ensure that climate policy takes into account these types of justice claims, and at the very least, looks at ways in which to balance those places where there's a tension between speed and efficiency and fully addressing the justice claim. I also want to argue that in doing this in a systematic way, we can find lots of win-wins where there isn't necessarily a tension between cost effectiveness and speed on the one hand and achieving justice on the other. But that isn't always possible. So let me first start by talking about why I'm focusing on administrative climate change policy action. And I already mentioned it before. Basically, legislation is messy, and in thinking about this, I haven't found any good way to put guardrails on it and say, this is what legislators should be taking into account or should be thinking of. It's not to say that I don't think that legislation isn't the place to be doing lots of this stuff. In practice, for example, in California, there's an iterative relationship between the way that justice gets taken into account in legislative climate change policy and the way that it gets taken into account in administrative climate change policy. But let me suggest to you some types of climate change policymaking that is well suited in the administrative arena. So in particular, I would suggest that justice claims that are closely related to the climate change policy itself are well suited to the administrative arena. So for example, corrective justice claims, places where if the legislative mandate is to promote electric vehicle use and the harm that we see is that the main tool is only available to higher income individuals, then that's a good place for the administrative agency to be tasked with analyzing the justice impacts and addressing them. A second criteria that we might take into account is that where there are mitigation strategies available that are not so cost effective, or not so costly that they overwhelm the cost of the entire program. So where, in the EV example again, we have options to use some of that funding to promote electric buses, public transit, other forms of transportation where we can tier to some degree EV incentives to income or prohibit them from being used for luxury vehicles. Those are all ways in which we can, in a relatively, without overwhelming the budget of the whole program, address some of the justice concerns, and I suggest that's a good thing that an administrative agency could do. Finally, when we're dealing with justice claims that impact a small group of people that don't have a lot of political power, and I'll point you back to that idea of a power plant, where you've got one power plant closing down in a state, and it only has, and it's the people who work there are only represented by a few constituents in the state legislature. Planning for that kind of a situation where those folks don't have the kind of political power necessarily to achieve legislative change that addresses those justice impacts, that's a good reason to delegate authority to an agency to address some of those justice impacts. Finally, let me provide two other things that we should be thinking about. One, the agency that this is delegated to needs to have the authority to do this. And oftentimes that's an issue when it comes to the power of the purse. It may also be an issue, as Steve Ferry pointed out earlier today, in terms of some of the legal constraints of that agency. So we need to be thinking about what a Public Utility Commission can do to address some of these issues. Does it need additional authority? Can it constitutionally be granted that authority? And finally, I'll point out that in the distributive justice case, where sometimes we might think that, addressing distributive justice and making, trying to reduce income inequality may seem a far distance away from what we're doing in climate policy, and maybe therefore it's best left for the legislative process. I would say that there's an asterisk to that. If what we are asking the administrative agency to do is to reconfigure the rules that govern fundamental economic relationships And here we might again think of the Public Utility Commission and the drastic changes that are happening in the electricity sector, or we might think about the drastic changes that are going to happen in the transportation sector, where we're going to have autonomous vehicles, where hopefully we'll be moving to shared electric vehicles, maybe autonomous in the future. Those are dramatic changes to how we get around or how we use electricity. If an agency is being charged with doing lots of that, then we should maybe delegate to them the authority to do some really significant redistribution, because they're already mucking about with everything. And if we don't ask them to do that, then we are substantiating a status quo. We are reincarnating an unequal status quo through our basically affirmative action. So let me move on. Let me say first of all that what I'm saying is not new, something that I'm coming up with myself. I'm really looking at what states have already been doing, with California being the lead example, but also New York in its recent comprehensive climate change legislation that it passed. States are already recognizing that they need to take into account, or at least those states, environmental justice and climate justice concerns in the administrative process. Those two states also delegated broad authority to their air agencies to develop regulations to meet these very dramatic targets. So they've given broad authority. They've required that their agencies look at justice concerns, although I would argue that they could have gone further in the level of systematization that they could have required. So to wrap up here, let me talk about what that might look like. This idea that you might have a formal process for analyzing justice impacts in climate change policymaking and for looking at alternatives available. So again, this is based on the National Environmental Policy Act model, which at its core, without getting into any of the details, requires that federal agencies take a hard look at the environmental impacts of their actions and look at alternatives that might have reduced impact. Federal law does not require any specific that agencies reduce the impact, but only that they analyze it. Some of the state laws, like California's, go further and do require agencies to take mitigation actions. What I want to argue here is that what's particularly valuable is doing this kind of justice analysis and in a way that engages with stakeholders on the ground that are affected by this, incorporating that procedural justice analysis. So just as an example of what this could look like, I'd argue that agencies should, especially when they're taking significant actions or if they're doing comprehensive planning, which both New York and California are doing and which I know Professor Kazwan will be talking about later, that they look at specifically these different types of justice impacts and they try to do an analysis. What is the size of the justice impact? Who is being harmed? To what degree and how are they being harmed in a way that is discriminatory? And also that they look at how directly that harm is tied to the climate change policy itself, remembering that if it's more of an indirect harm, it might be better addressed at the legislative level. And then on the other hand, thinking about alternatives. What could we be doing differently to mitigate some of these discriminatory impacts of our policies? Or if we're mucking about with the basic economic foundations of a sector, to mitigate some of the existing regressive economic structures in that sector. Finally, I would argue that it's important, if we are taking justice seriously, to provide some role for judicial review of this type of environmental assessment. But here's where I think we do need to have some recognition that climate change is a little bit different. Because in climate change, we just don't have time. And so what does that mean? I'd suggest that it means that there should be perhaps a presumption in a kind of judicial review that courts don't undo or vacate major components of programs that have gone through a good faith review process like this. But that doesn't mean that they shouldn't feel free to send agencies back to the drawing board when there are still significant harms that haven't been mitigated. And so a good example of this is in California, when environmental justice communities challenged the cap-and-trade program or the decision to go with a cap-and-trade program, the judge there did find fault with the way that the California Air Resources Board carried out, met its California Environmental Quality Act environmental review requirements, but it didn't stop the program in its tracks. Now, I don't think people point to that as a perfect decision, but I would say is that there are options for a court to say, go back, figure out if there are increasing pollution burdens because of cap and trade, come up with a plan for how to address those burdens. That's not a really perfect overlay to that case, but I'm just trying to suggest that this is the kind of way that courts could deal with the tension between addressing climate change in a urgent and efficient manner, while at the same time ensuring that agencies take justice seriously. So I'll close with that and happy to take questions.
I'm happy to kick us off while you gather your thoughts for your questions. I'm curious, especially for Andrea and Julian, whose presentations focused, I would say if we were tipping the balance between justice and environment, more on the justice side than on the environment side, arguably. Do you feel like combining the issues that are addressed in the Green New Deal together and in the format that it is, in a resolution, strengthens the potential for outcomes in the areas that you're working on, or weakens them?
Should I go first? Okay, I think that's a wonderful question. We tried to do climate legislation about 10 years ago. It was called Waxman-Markey. I'm sure everybody in this room knows about it because you guys are all climate policy, environmental policy nerds. So we tried to do Waxman-Markey. The story of Waxman-Markey is that it came to the House, passed through the House, but never made it to the Senate floor for a vote because healthcare and financial reform were higher priorities at the time. And in one of the sort of most widely cited analyses of what happened and what really went wrong with Waxman-Markey, because a lot of the sort of backstory of this conversation that we're having right now and about the Green New Deal in general is on top of the grave of Waxman-Markey, right? It's because the last generation of climate policy did not happen. Theda Skocpol, whose name I usually don't pronounce correctly, talked about how there was one of the biggest problems with the fight for Waxman-Markey was that there was not enough civil society engagement on the bill, that it was a very sort of inside-out sort of strategy to get legislation across the finish line that sort of built from what the most middle-of-the-road sort of politicians might be able to, senators really, might be able to agree to, and then built outward from there. And I think that the theory of the case on the Green New Deal is much different. It starts with what we might be able to build public support and engagement and excitement around, and then worries about the senators later, because there's sort of a consensus among, I would say, progressive sort of movements and activists and politicians that the public opinion on a lot of these things is rapidly shifting in our favor, and at Data for Progress we tend to find that that is the case. And so the real reason why I do not think that there is as much a trade-off between the jobs and justice, which people say is going to make the decarbonization cost too much, and sort of the fight for comprehensive climate legislation, hopefully in the form of a Green New Deal, is that we need to build a durable public coalition, a coalition that includes young people, environmental justice communities, unions, and green groups in order to really sort of push that legislation across the finish line. But we don't only need to get that legislation across the finish line, we also need to make sure that it's durable. Of course, if we pass climate legislation in 2021 and Republicans come into power and repeal it in 2025, then we will not have gotten the job done. And the way in which you get communities, you get the public to buy into legislation to make it durable, we have a very strong example of that in the last couple years, and that's Obamacare, right? So Republicans came into office, the Tea Party allegedly came into office under the promise that they were going to take away Obamacare, but when they actually tried to do that, they faced significant opposition from communities that were calling their members of Congress, calling their senators, taking to Capitol Hill, protesting, doing all of that sort of legwork to defend their right to health care. And we need the same sort of thing with climate policy. We need to make sure that the public, that unions, that organized interest groups are bought into climate change legislation such that if there is a sort of turnover in the makeup of our legislature and who's in the White House, it is not so easy for a more conservative movement to push out climate, to push upend sort of a new climate law that we might pass. And of course, this is especially important because we've seen sort of around the world ways of doing climate legislation that lead to a backlash in the public. The examples are growing, it seems, every year. So we had, of course, the Yellow Vest protests in France, which were in large part sort of repudiation of Macron and his climate policy, his carbon pricing policy. In Australia, we saw something very similar, and in a couple of weeks, Canada is going to vote, and we're going to see if there's a similar repudiation of their carbon taxing sort of scheme. And so I think that it's really, really important. Actually, I think the strongest case, perhaps, for justice is not that it's the right thing to do, although I do think it's obviously the right thing to do, but is actually from a sort of durability and scientific perspective that we need to get people bought into climate legislation if we want to make sure that we actually enact and then sustain those emissions reductions.
So I think it's really exciting that food justice is part of the Green New Deal, even though I have not seen it get very much attention. Did a lot of research for this symposium, and not many people are talking about it, but it is left out of most conversations because most environmental law does not include food. Food law does not include racial justice. Racial justice does not include food issues. So to see the completeness of the idea embedded into the resolution, I think, is inspiring. We wouldn't be talking about food justice today if it wasn't in there, but I don't know how far it's going to go because I see it kind of being pushed aside.
Okay, I think we have a microphone here for audience questions.
Hi, I really enjoyed each of your presentations. I had a question for Julian. In your presentation, you spoke about how, and I'm going to pronounce this wrong, but the Oceti Shikoan?
That was pretty good, yeah.
Of the Black Hills, they were harmed by the breach of one of their treaties, and essentially they refused to accept compensation. Apparently they were damages up to 88 million, now it's 1 billion. And I'm just a little confused to why haven't they accepted that, or is that a settlement, or is that, what is that? And just a little bit more detail about that.
Yeah, so the tribes in South Dakota, the Lakota in South Dakota, have decided not to accept the settlement, the money that was awarded to them in 1988 as a Supreme Court case, because they insist that the Black Hills are still theirs, and so they don't want the money, they want the land. And so their view is that the land was, and the Supreme Court's view is that the land was unjustly stolen, and that therefore the Black Hills, which are sacred to them, should simply be returned.
And is that how they've been fighting the pipelines for all these years, or is that something a separate case?
They've been using. There was 2 major treaties signed with the Great Sioux Nation. The last one was the Fort Laramie Treaty of 1868. Is that what I said? I think this. I'm not the best on the dates. Was that right?
I don't know, but you're
Okay.
fine, yeah.
Okay, so let's say it's 1868.
No one here is going to correct
You can play back the recorder from earlier, and we'll get the right date. It's in the notes. But yeah, so there's a number of stipulations in that treaty, actually, that are quite interesting. There's also Okay, I'll give you some insider information here. There's this portion of the treaty that's called the Bad Man Clause, which is supposed to allow the tribe the right to have jurisdiction over bad men, people who commit wrong and crimes on their tribal lands. And so there's actually some discussion among activists they might like revive this right that is written in the treaty that is still supposed to be the supreme law of the land and use it actually against fossil fuel corporations. It could be very interesting, for example, if they decided to take, as a number of jurisdictions are, fossil fuel corporations to tribal court for the violation of treaty rights and that sort of thing. So the treaty has, to answer your question more directly, has a number of different sort of stipulations within it, which include things like provision of food and healthcare and schools and all that sort of stuff as well.
Yeah. Julian, NoiseCat, you mentioned making decisions with indigenous communities rather than for them. Can you speak about a little bit more about what that looks like in the Green New Deal context?
Yeah, so just look at my notes real quick. So Gabe brought up that the environmental justice movement, in a lot of ways, is rooted in this notion of procedural justice, right? And so there's a very specific movement history to that comes out of, firstly, so the environmental justice movement, just to back up, essentially comes out of the fact that the United States disproportionately cites toxic waste, mines, industrial facilities, pipelines in communities of color. I'm sure most people in this room are very well aware of this, and actually comes out of a specific history of litigation and then also nonviolent civil disobedience. And in the 80s and 90s, this sort of movement starts coalescing into like a national movement. There's a gathering of environmental justice leaders of color in Washington in 1991, and they write 17 principal points on environmental justice. And then in 1996, I think, there is this other environmental justice gathering, a document that is often cited, which is called the Jemez Principles for Democratic Organizing, which was a document that was drafted between environmental justice communities and actually at the time progressive organizations that were working on trade deals, because that was sort of the big thing in the 90s, if we all recall, and has become enlarged into a general sort of statement about the way in which community-based environmental justice organizations work with big green organizations and other progressive organizations. And in fact, some in the room might be interested to hear that organizations like the Sierra Club, the Natural Resource Defense Council, the League of Conservation Voters, a whole bunch of organizations that you would maybe not identify as signing something called the Jemez Principles for Democratic Organizing are at least nominally committed to those principles. So I would say that it's actually something that is that in some ways comes out of a broader environmental justice sort of movement history and demand for a seat at the table and for equal treatment. But in the indigenous context, it actually also comes out of a much deeper history of an understanding of our communities as sovereign, as nations in and of themselves, that we were here, long before the nations that were built on top of our homelands. Not very far from here, there is still remembered and honored the Guyana Koa, which is the Great Law of Peace, which is a 500-year-old constitution that the Haudenosaunee Confederacy maintains. They actually recited it and brought it back into law just this August. And so there is an understanding among indigenous nations that the relationship needs to be nation to nation, that it is of, the Oceti-Sakowin to the United States. And throughout history, that nation to nation relationship has been invoked in many different contexts.
There's a question in the back.
Hi, thank you all for coming and speaking today. My question is more on the demand side of the Green New Deal. I'm curious as to how these privacy laws, data privacy laws will impact the Green New Deal. The reason I ask this is because smart meter data is used to collect very granular and revealing data on people. So states are now passing data privacy laws to protect people's data. So I was curious as to how that might affect the Green New Deal in the data-based analytics that are needed to make smart grids smarter. So I was just curious what you had to say on that.
Not sure this is the right panel, but I don't know. You work in a data organization, so I think that's for you.
Are you guys recording?
Yes.
Okay.
We can
Turn it
pass
off.
if you want.
No. I mean, so I think it's a very good question. I don't think there's like I get to work with a lot of experts, and I don't know if any of them would have a really fully formed answer to it yet. So that's part of why I think it's a good question. I think that we work with a lot of data for progress. It's in our name, which means that we do a lot of public opinion polling and analysis to try to understand, where people stand on a lot of the issues, and we generally find that people are more progressive than political elites think they are. And so, insofar as data privacy is like an important right that I think we need to be protecting, because otherwise the Facebooks of the world have a lot of power. I think there are also some interesting lacuna and sort of idiosyncrasies in here, wherein fairly savvy progressive media actors can actually use data in some ways for good. So it's not a completely straight and narrow, one-directional street on that issue. For example, Ocasio-Cortez would not exist without social media and new media. A lot of the things that we do rely upon existing media infrastructure. What that means for grids and all that sort of stuff, I'm not really sure. I think The Economist probably writes interesting articles about stuff like that, but I don't have much of a take on it other than that.
I got nothing.
I think we've got another question up here. Sorry.
Sorry, I had to ask the question after someone all the way across the room, so I apologize about that. But, okay, so we've seen instances in which facially positive green laws actually contribute to injustice. So, for instance, I'm thinking of the Paris Agreement biofuels mandates being met through illegal land grabs in Southeast Asia and Sub-Saharan Africa that they do contribute to poverty and hunger. So we can't have just green, clean laws without considering how they affect everyone globally. And I'm just curious about how everyone on this panel believes we can make those just green new laws successful both domestically and globally.
It's a really good question. I mean, I think that domestically seems to be easier for me. At least that's the one that I think I've spent more time thinking about. And I think the premise of your question is a really good one. I'm really concerned about even the best intentions of laws creating injustices. And I hope that a start is something like the kind of systematic analysis that I outlined, but I don't believe at all that that's necessarily sufficient. One of the things about climate change is that we need to act quickly, but we're going to be acting for a long time. And I think what we've already seen is the importance of iterative processes. So we've seen, for example, both in the RGGI process, the Regional Greenhouse Gas Initiative, the Cap and Trade Program here in the Northeast, we've seen in California that those states have come back repeatedly through both administrative and legislative processes to reevaluate their climate programs, and justice issues have come up in those reevaluations. And I hope that the programs have strengthened their justice focus through that, although I think many people would be unsatisfied in both of those situations. Professor Casman is nodding in agreement. But on the global level, I think the challenge is much greater. There are mechanisms again, to do this kind of iterative review process in the Paris Agreement, but I don't know that there's a sufficient enough emphasis on justice in that because I don't know, it's not my area of expertise.
So for food justice, obviously the food system has become increasingly global, and what happens here has a large effect on the rest of the world. And so I think that sort of wresting control of the food system out of corporations' hands would have a positive effect on the rest of the world, because the more junk that we eat and produce here gets marketed to other countries, and we're seeing reproduction of the health problems that we have, particularly in the more marginalized communities here, in the globally marginalized communities. It's reflected. So that, to me, is the primary agenda of food justice, is to get corporations out of it.
We have one more question.
I could respond to that one too, actually. So I think from the interestingly, there's been Green New Deals now popping up in Canada. My friend works for Yanis Varoufakis, and they're doing a Green New Deal now too. The UK Labour Party is now talking about a Green New Deal. But the commonality between all of those places where this conversation is happening, at least under the banner of a Green New Deal, is that they're all in the global north. And that all of those networks are among, educated people in the global north. And there's not as much sort of conversation with folks in the global south, which I think would entail conversation about, what is owed to the nations and low-lying nations and island nations that contributed the least to global warming and are going to bear the most intense, or already bearing the most intense consequences. So I think that just like from a very basic level on like who professionals who work on this, like what we do, I think we need to talk to more of those people and more of those experts. But then, like locally, I was also in Chibougamau, Quebec last week, which is in northern Quebec. It's a mining area. It's an area that's been based on first fur trade, then logging, and then gold mining for a number of decades. And now, with sort of the possibility very soon of people shipping through the Arctic, they're talking about opening a port in northern Quebec. And there's now investment coming into those same mining communities, but instead of looking for gold, now they're looking for lithium, and they're looking for lithium to export to China, right? And so I think that, I think Gabe was talking about the ways in which, environmental harm can still be perpetuated under green and clean type sort of transitions. And unfortunately, the reality is that it is often the exact same places and communities that are going to be facing that reality. I don't think that means that we shouldn't take action on climate change, right? Like everyone is way worse off if we don't take action. But I think we also have to be clear-eyed about the fact that a number of these issues are going to continue, and that there is a decent probability that if we don't get this right, transmission lines will simply replace pipelines. In the future as a environmental, a fair siting and environmental justice issue.
Okay, so we'll do that one more question, then we'll wrap up.
Hi, my question is for the panel. One of the critiques of the Green New Deal resolution is that it's focused on getting to net zero emissions by 2030, and looking at global energy policy it's not necessarily looking at phasing out of coal, oil, and gas and other fossil fuels. And so potentially those fossil fuels could still be extracted, transported, and exported overseas, and those impacts can tend to have an unjust relationship to communities, because many of the places where extraction happens, where this transportation goes through, are marginalized communities in this country. So are there some ways that are being looked at to improve the writing of the Green New Deal so that it may address sort of the phasing out of all fossil fuels?
I can maybe get started in not answering that question. But You know, the Green New Deal resolution is fantastic as a conversation starter. The blueprint that Data for Progress did is even more detailed than the resolution itself. But it's a non-binding resolution, right? So I would imagine, although I'm not involved with any of the architects of the Green New Deal, that there's a lot more to think through there. And we certainly have examples of other climate policies that have tried to address that in some way, for example, through border adjustments, which more has to do with imports. I'm not aware of specific mechanisms that have gone the other way, but I certainly think that's a really important concern. I can tell you that from what I know about border adjustments, that's really, really challenging and creates lots of problems. I would imagine that there are some of, not necessarily problems that can't be solved, it's just a really thorny policy issue, and I would imagine that some of the same, some of the same problems work the other way around. But
So I think that's a great question, and I think that there's a number of landmines in the sort of broader climate policy space. You brought up the term net zero, which is particularly sort of triggering for environmental justice communities, because for them it is often read as we will continue to do the same sort of perpetuate the same polluting industries in your community. On the other hand, the other term that you use, fossil fuel phase out, is obviously it's a non-starter, to be clear, for almost every single union in the United States, aside from probably the National Nurses Union and maybe the Service Employees International Union, maybe. And so I think that there are a number of these sort of wedge issues in the broader sort of coalition that is coalescing around the Green New Deal that particularly on policy issues are very delicate. And I also think that there are big policy questions that we don't frankly have great answers for, right? So for example, like air travel. We don't really have a great solution to air travel with existing technologies other than to do a whole bunch of research and development on it. Similarly with shipping, et cetera, concrete production, steel production, all these sorts of things. So I think one thing that I would really commend a lot of the sort of youth leaders at Sunrise of doing pretty well is about being very clear about what their values and principles are, that they are in it for a Green New Deal that centers jobs, justice, and climate action. But I think being a little bit more open, I would say, than a prior generation of sort of folks in the broad environmental movement in sort of moving forward despite these sort of areas of tension, that these areas that we still need to figure out some very thorny issues that have troubling backstories that include real harm perpetuated against communities, because the bigger picture of trying to get this right is just, I think, basically at this point, a moral imperative. So I think that it's a great question, because I think you've identified one of the sort of key sort of points of tension between people who are more or less on similar pages. And I think the key to a lot of this sort of being able to move forward and hold together is to be able to have conversations about things like that in ways that are productive, rather than sort of dividing the coalition along lines that it's always been divided, which has obviously been the history of jobs versus environment framing, or big green versus environmental justice communities, and that sort of thing.
Great. Well, I think those were all student questions and a bunch of 1Ls. So thank you for those very tough questions. And thank you to our panelists. This was a great conversation. We'll give you a round of applause. And now I believe we have a break until 2:45. We have some refreshments for you over here. Thank you.